Hello everyone, welcome to Ugly Spoon's channel. First, let me wish you a happy Lunar New Year. May the year of snake bring you good fortune, good health, and success. In this video, I'm going to talk about Trump's executive order aiming to end birthright citizenship for immigrants. I'll try to explain the background of birthright citizenship, the legal basis, and controversies about restricting it, as well as the practical difficulties in implementing such a policy. If you are interested in topics like this, please subscribe to my channel. There is also a Chinese version of this video, which I will link it here. On his first day in office, Trump signed a series of executive orders. One of the most discussed was the one addressing birthright citizenship. Let's first take a look at the text of the order. The executive order references the 14th Amendment of the Constitution, which lays the foundation for defining U.S. citizenship in modern times. Let's take a closer look at what the 14th Amendment actually says. Now, Trump administration's legal argument for this executive order hinges on a reinterpretation of the 14th Amendment that deviates from over a century of mainstream understanding. The administration claims that individuals who are in the U.S. temporarily or illegally are not subject to U.S. jurisdiction. Before the Trump administration brought up this issue, the most famous case related to citizenship was the 1898 Wong Kim Art case. Mr. Wong Kim Art was a Chinese American born in the U.S., whose parents were barred from becoming citizens due to the Chinese Exclusion Act. After a trip to China, Mr. Wong was denied re-entry to the U.S. because of the restrictions on Chinese immigrants. But Mr. Wong argued that, hey, I was a native-born American. The case eventually reached the Supreme Court, which ruled that anyone born in the U.S. is subject to the U.S. jurisdiction and, therefore, automatically a citizen. This precedent has stood for over a century. Now, the Trump administration seeks to overturn this long-standing precedent and change the interpretation of the 14th Amendment. As of the time I'm recording this video, Trump's executive order has been challenged by over 20 states and has been blocked by a federal judge. Trump himself has expressed that he's not surprised by the ruling and intends to appeal. The case will almost certainly be decided by the Supreme Court. This brings us to the key question. In the Supreme Court with a 6-3 conservative majority, could the justices adopt Trump's interpretation? Well, I believe it's not out of question. The reason is that, as we've discussed, the 14th Amendment is the basis for birthright citizenship. But you might not know that another landmark case in 2022 also related to the 14th Amendment. It is the now overturned Roe v. Wade. The abortion issue concerns the last clause of the first section, a quote, "nor deny to any person within its jurisdiction the equal protection of the laws." A birthright citizenship, on the other hand, pertains to the first clause. In 1973, the Supreme Court used the Equal Protection Clause to establish a precedent for abortion rights. However, the current Supreme Court overturned that precedent, showing a willingness to reinterpret the 14th Amendment. This suggests that they might also be open to change the interpretation to other parts of the 14th Amendment, resulting in overturn of the Wong Kim Art precedent, aka the birthright citizenship. However, I believe that Trump's interpretation of subject to jurisdiction has a significant flaw. Let's say, for legal visitors to the US, they technically imply that they do agree to US jurisdiction when applying for visas or entering under visa waiver programs. And for illegal immigrants entering the US, they still interact with the government. For example, by turning themselves in, applying for asylum, or attending court hearings. Now, these interactions demonstrate US jurisdiction. It is very hard, if possible, to argue that they are not subject to US jurisdiction. Well, so far, neither the Trump administration nor its supporters have provided a convincing explanation for this issue. And then it comes with implementation issues. Even if the executive order is legal, implementing it could be a logistical nightmare. Well, currently, almost all babies born in the US are automatically citizens. So, birthright serves as de facto proof of citizenship, enabling applications for, let's say, social security numbers, passports, and other documents. The only exception is children of diplomats, which is manageable due to their small numbers. But if certain newborns are no longer automatically granted citizenship, who will determine their status? Hospitals cannot take on this role, as issuing birth certificates is about recording the fact of birth, not determining the baby's legal status. This responsibility would fall on state agencies recording birth rights, the Social Security Administration issuing SSN, and the State Department issuing passports. However, verifying parental status for all newborns would require significant resources, time, and could delay benefits. Additionally, if foreign-born children don't receive U.S. citizenship, theoretically they should obtain their parents' nationality, right? But if parents purposely delay this process, hoping the executive order would be overturned, then practically these children could become stateless. Well, I don't think you could compel parents to register their child's citizenship with foreign embassies. In conclusion, birthright citizenship is constitutionally guaranteed. Except for diplomats, all children born in the US are automatically citizens. And I do support this principle as it reflects Americans' openness and inclusivity, which is fundamental to American dream. However, abusing birthright citizenship, yes, abusing, by giving birth in the US solely for citizenship benefits, I would say is irresponsible. It will result in either intentional separation, such as sending US-born children back to their home countries, or unintentional separation, such as deporting parents while their US-born children remain. These scenarios would no doubt harm children, and I would argue that the benefits of US citizenship may not outweigh the trauma caused by such separations. Ultimately, children are innocent, and forcibly stripping their citizenship would only create more problems. That's it for this video. If you enjoyed it, please like it and subscribe. Also, what are your thoughts on birthright citizenship? Feel free to comment and join the discussion. I'll see you next time. Bye.